Hello and welcome to the Genetics Podcast. I'm your host, Patrick Short. My background is in population genomics and studying the genetic causes of rare disease. I did my PhD at the Sanger Institute in the University of Cambridge and have been in biotech since 2018 when I started Sonogenetics. Sonogenetics helps academic and industry researchers to run large-scale genetic testing programs that speed up their clinical trials, generate data sets for the next big breakthrough, and give participants the best possible experience taking part in research. Each episode of the Genetics Podcast, we bring you insights from the leading minds in genetics and precision medicine, including household names and Nobel Prize winners, as well as early career scientists and biotechs working on the next big breakthrough. Whether you are a scientist, entrepreneur, executive, patient advocate, or simply someone curious about how genetics shapes our world, you're in the right place. Thank you for listening, and let's get started. Hi, everyone. Welcome to the Genetics Podcast. I'm really excited to be here today with Glenn Cohen, who's professor of law and deputy dean at Harvard Law School. He's one of the world's leading experts at the intersection of bioethics, health law, and emerging biomedical innovation. We're going to talk about genetics, reproductive technology, maybe polygenic risk scores, and lots of other exciting things. So Glenn, thank you for taking the time to join me.
Thanks for having me.
What's your background there? It must be Harvard in some way, shape, or
law school classroom, exactly. This is the classroom I teach in, but I joke I must not be a very good teacher because the photo has it empty.
They're all zooming in for the day.
Yeah.
So yeah, let's talk a little bit about what do you teach? What have you taught over the years, and what are the sort of things that you and the students are interested in? It's one of the best law schools in the world, probably the best, depending who you ask. But I'm really interested to hear.
We'd like to think we're very good, and we're very lucky to have amazing students and have amazing colleagues. My specialty is the intersection of law, medicine, and ethics. I would say I'm dual trained as an ethicist and as a lawyer. So over the years, I've taught different stuff. I've taught courses on reproductive technology and genetics. I've actually taught a couple of times a new course in psychedelics in the law. I used some work on the therapeutic use of psychedelics, which is very interesting and legally hot. Taught general health law surveys, but then I also teach a course on bioethics and film, where we watch some films, not-for-credit course, a reading group. We talk about some of the ethical issues they raise and have readings. And I teach civil procedure, which is the basics about how to bring a civil lawsuit to the first years, because I used to be a litigator in a prior life.
Oh, amazing. What are some of the topics right now that are particularly of interest to you?
You know, I work on a variety of stuff. I'll say a little about the non-repro stuff, and then I'll say about the repro genetic stuff that I do. So non-repro world, as I mentioned, I work on psychedelics. I work a lot on FDA law and the approval of drugs and devices. I work a lot on AI in medicine. Do some work on organ transplantation, organ allocation, and some neuroethics stuff connected to that. And then in repro, I do mostly what I would call cutting edge. Used to do a little bit more on surrogacy, IVF, and the like. Still do some. But now I do things on in vitro gametogenesis, mitochondrial replacement, uterus transplants, polygenic risk scores. So I'm kind of a junkie for stuff that's really on the cutting edge of medicine. And I love that I get to spend time with folks who actually do the work and do the research, and I learn about it as I go.
What, within that realm, if we dive into the repro side, what are some of the most tricky ethical and or legal questions right now in the field that you're wrestling with?
Yeah, great question. I would say there's a couple of them. So first of all, I think some of the very cutting edge stuff like in vitro gametogenesis, which of course involves deriving sperm or egg from a somatic cell, skin, for example. I think that just blows people's mind when I tell them that we're doing this in animals and we could successfully do it in human. There's some legal questions, including an appropriations rider at FDA that blocks some of their review, and thinking about if FDA were to review this, what would it look like? So that's very interesting. I think the polygenic risk scores are pretty interesting too, in part because, again, we don't have a great paradigm at an FDA for reviewing it. What are the tort implications if you have a risk score that turns out to be crappy? What's your obligations to test, retest, and update, given that we're actually improving the underlying GWAS data and kind of the diversity of it? So that's quite interesting. And it's stuff like people just don't know about. So the fact that we can transplant a uterus from somebody who's deceased or even someone who's living to another person and allow them to have the experience of pregnancy. This raises interesting issues, and people, don't really know too much about it. And so I love telling people about it.
Yeah, I have never thought about that one, but it makes total sense. I've talked on this podcast before about we've got a lot of kidney transplants in my family. We have a genetic kidney disease in the family. And so I'm used to talking about transplants, and there's ethical issues abound with that. What are there ones that maybe people wouldn't be familiar with that are specific to the repro space?
One is just a question about whether it's worth doing this, right? Because notice that we're not trying to achieve just genetic parenthood. You could do that with a surrogate, for example, although we'd have some risks to the surrogate. We're talking about maybe someone go through a transplant and immunosuppressive therapy, right? For what? For the experience of having the experience of pregnancy. Is that the kind of thing that's valuable? Yeah. Is that the kind of thing we should be spending money on? Also, it doesn't matter where the uterus comes from. It doesn't matter that actually the experience of pregnancy might be a little bit different. And then the thing that I'd say tell people that really blows their mind is that some of the transplant surgeons I talk to tell me that in principle, we haven't done this yet, in principle, there's nothing to stop us from transplanting a uterus onto a male pelvis. So we could actually have a cisgender men or trans women kind of experiencing pregnancy as well. Would that be a terrific thing? Or would that be like, what the hell are you doing? Why are you doing this? And just to think about what it is about pregnancy as a marker of a connection to a child that we think of as important.
Yeah, fascinating. So I want to jump into the point, and maybe we'll spend a little bit of time on this one. You raised the idea of, hey, we have maybe a crappy polygenic risk score, and what are the tort implications? We have companies, it seems like it's really grown in the last couple of years. Some are focused purely on medical applications, some, medical and more broadly, like eye color, height, something that maybe closer to the quote unquote designer babies. Can you talk a little bit about how do we think this is going to play out? And then what are some of the different routes that it might go down as these evolve?
Yeah, great question. So one issue is just to say, will FDA have any authority on reviewing these? And I'm doubtful that they will. They are technically devices and technically in vitro diagnostics. But, the Biden administration wanted to regulate lab-developed tests and had a rule that it put out in 2023. It was struck down by a district court saying that tests were not devices, so no good. And then essentially we went back and the Trump administration refused to defend the rule in court on appeal. And so now the rule is a nullity. We do have CLIA. We do have the Clinical Laboratory Improvement Amendment of 1988, but it's all about analytical validity, not clinical validity. And I think most people think that's where the important thing is. And then even if you had a regulator looking at it, this question of updating it is tricky. Now, some of the stuff in terms of how it's being pitched, you could have consumer protection laws. So the FTC, for example, Federal Trade Commission could look at this. I think it's very unlikely they will. So that now everything goes back into say, well, I guess we're going to have liability and tort law be the thing that people worry about and look at. And here I just think there's a lot of difficult questions, like what's the standard of care for giving this information? It's brand new. Where does the liability lie between the person who makes the test versus the person who interprets the test? And how do we think about that division? Also, in theory, if you get a test that's improperly performed, it causes you to select, or interpreted, causes you to select an embryo. The embryo you implant produces a child that has a disorder. You could bring in some states what's called a wrongful birth lawsuit. The problem is that actually many states actually restrict those lawsuits to mistakes that occur post-pregnancy, not pre-pregnancy. Right. And even then, most of the disorders we're talking about, cardiac, oncology, mental health disorders, are going to manifest after a child, like a little
50 years from now.
Yeah. Or at least after age 18.
Yes.
And that produces some practical problems in that, for one, the statute of limitations may have run. And then even if it hasn't run, typically in wrongful birth cases, what you get is the damages of the extra cost of raising a child because of the disabling condition until age 18. So that's not going to help you. And then finally, I'll just say, that's all for tests that incorrectly rule in an embryo. What about cases that incorrectly rule out an embryo? An embryo was perfectly good, but the polygenic risk score suggests otherwise. Here we really have no good legal category to kind of bring those actions. We have cases about freezer failures where the embryos are actually destroyed, but most people are not discarding these embryos. They're instead continuing to freeze them. So, you find out 20 years later and you could have used that embryo. Well, exactly how do you bring a lawsuit about that? What are your damages? This is really new territory.
Yeah. And how much of this is specific to polygenic scores versus maybe more plain vanilla PGT that's working on a monogenic condition?
Yeah, I mean, I think that they're not radically different, but some of it is different in the following respects. Is that the monogenic tests, first of all, they tend to be well validated, across multiple populations, as opposed to things that are going to be really dependent on ancestry and the quality of the GWAS. They also tend to mostly focus on lethal, early onset, life-threatening sort of stuff. So some of those problems don't manifest. But there has been lawsuits, for example, about PGTA on aneuploidy, and there's actually a big variance in practice. I'm not a reproductive endocrinologist, but I understand that widely used in the US, not so widely used in Europe, and there's questions about whether it's about the payment structure. And, kind of the negative story is because actually fertility clinics make money on it and people are self-pay, that's very different than in Europe or Canada, where the state kind of and the insurance process has a role in kind of determining whether this is good or not.
Yeah, interesting. You are, so I guess from this, it seems like we're in a little bit of like a gigantic gray area. What do you think a new regulator steps in, or are the timeframes and the ability to actually draw a line from a hypothetical harm to the cause of that harm so difficult that we may just live in this world of uncertainty for a really long time? How do you think about that?
I think we'll live in the world of uncertainty, although I want to be careful to kind of suggest it's uncertainty. I think the actual liability risk is low. Maybe it's too low, actually, that in my preferred world, we'd have higher liability risks. But the reason I don't think regulators are going to step in is, in general, the federal government and even the states have proved relatively uninterested in regulating spaces of genetics and species of reproductive technologies in particular. And I think what's interesting is that you might think, well, we have conservatives who care a lot about abortion and embryo destruction. But actually, if you look at something like the case in 2024, when the Alabama Supreme Court ruled that an embryo was a child for the purposes of the wrongful death of a minor statute, and suddenly it looked like all these IVF clinics were going to have to close in Alabama, we had even very conservative members of Congress and even the president rushing in to say, no. And the Alabama state legislature, a very conservative state, rushed in to protect these banks. So I think that actually you would find little interest on both the left and the right at the federal level and even at the state level for regulating here. Too little interest in my books, but that's the political reality.
Why do you think they have little interest in it?
So I would say it's a couple of things. One is to say, I think the fertility industry and the genetics industry have been successful in lobbying. The other is I think that actually it's a loser of an issue politically, and that it tends not to actually divide up your base in a very good way, because you'd find that most people have liberal attitudes towards access to reproductive technologies. And the people who've been burned, like they've gone through too many IVF cycles and they feel like they were misled, are like a small minority of patients. And I think that even then, you're worried if you're on the left, for example, about signaling an interest in limiting reproductive autonomy, even if it is in this kind of consumer protection mold. And I think the proof is in the pudding that we've had, it took a long time to get this lab developed tests thing go forward. It was struck down, the industry fought it. When you look at federal regulation of in vitro fertilization, the main statute is one about just reporting results rather than actually limiting. And this has been a space where actually we see huge amounts of variation, self-pay, that kind of stuff.
Yeah, interesting. How about AI? You're doing a lot of work on the impact of AI across medicine more broadly. What's the most interesting area to you right now?
Super interesting stuff. I think the stuff that's relevant to, AI has fueled some of the GWAS work, which is very interesting, and it's going to fuel a lot more, including embryo selection, AI-guided embryo selection, and stuff like that. The stuff I'm the most interested in is, again, questions about liability, who pays. There have been very few cases on the subject. Questions about, should some kind of regulator look at AI before it's implemented? Most of the medical AI in the United States is outside of FDA's remit and purpose. And how is that working for us? Do we think we need more? Could you do it in a way that is efficient and that is able to meet the demands of AI developers? Thinking about implementation, because my own view is that you can show me a great AI that works great on a new verification data set you send me. But then when I look at the actual implementation, I find it's both not doing what it's supposed to do, and it's making new errors, and the way it's being integrated into a team environment is just not well suited. I often say you have to hire an AI rather than buy it. And just as you would never like hire a trauma surgeon and then never look at all about how he performs, whether he is sexually harassing patients, whether he's getting along with patients, whether he's showing up drunk, it would be ridiculous to just buy an AI and like just hope for the best.
Right.
So who looks at implementation? How is that regulated? What kind of liability for poor implementation? And then thinking more generally about questions about bias, questions about populations, questions about deployment.
Yeah. And do you have a framework for how we can think about trade-offs between something like access and bias? I think, for example, the chat tools are increasing access by orders of magnitude to high quality information, but then they also are increasing access by an order of magnitude to hallucinations or low quality information. Like what's the, and there will certainly be bias as well. How do you think about weighing those sorts of things up in these questions where you've got two very different vectors that we're scaling on right now?
Great question. So let me give a short answer because it's actually quite a hard problem moving comparability, and the philosophers would love to talk at length of this, but I'll be briefer on this, which is to say as follows. I think one of the questions you ask yourself is, what is this doing? Is it giving me the kind of conversation a clinician might have in the hallway with another doctor, or is it purporting to offer expertise that deserves trust and I should have an epistemic warrant? When it's in the first category, I'm less worried because it turns out that actually our colleagues, our memories, all these things also produce hallucinations. I often say that this black box ain't so good all the time either. When it's purporting, though, to do something that is like, you should trust me, and I want to induce automation bias and reliance, now I think we have to look more carefully. So that's the first answer.
Yeah, interesting.
Second thing is I tell hospital systems just to say, we have a box of like benefit and risk. When things are low risk but high benefit, you want an internal process that makes adoption frictionless or less frictional. When things are low benefit, low risk, or high risk, low benefit, maybe you just want to have a system that detects that and excludes it. It's not probably necessarily worth your time to kind of spend a lot of time on it either way. It's the high risk, high benefit box that you want to be spending a lot of your time, and you want to have a local way to make sure it's going to work for you and work for your patients. And that's really what we care about. And but doing that, studying the implementation and maintaining kind of records on it and proving to yourself it's still helping, that's not a small undertaking. So at the early part, I think one of the issues we have is actually distribution between have and have-nots academic medical centers. Fancy academic medical centers have the expertise and the money to do really good workups on new algorithms. The poorer ones, maybe not. And so maybe it's a story of technology diffusion for the higher risk, high benefit stuff.
Yeah, really interesting. You've been able to provide amicus briefs to some pretty important Supreme Court cases over the year, like Association of Molecular Pathology versus Myriad and a number of others. Can you talk a little bit about where do you decide you're going to weigh in and offer a perspective? And maybe you could talk about one or two of the ones that you have and the impact.
Sure. So I was a litigator before I became a professor. I was an appellate lawyer at the DOJ. So my job was writing briefs to the courts of appeals and a little bit of work with the Solicitor General in the Supreme Court and arguing the cases. So people sometimes find me because of that. There aren't too many people in health law, bioethics, biotechnology, who are academics who have that. Yeah. People usually approach me to say, we're thinking about this is an important case we've identified. We think it's really important in particular to hear from either the science community or the ethics community. And we want someone to play a translational job in kind of doing that. And one of those, Mayo, which was like a case about the patentability of genes. And, there, Eric Lander, who I happen to know via other people, kind of just called me up one day and said, I really think it's important because I think the Supreme Court is going to muck this up. I have this view about a difference between, cDNA and regular DNA. I think we should just articulate that to the court. Can you help me? And so I found a colleague who was in private practice, and together we drafted this brief. And then I was delighted when it made its way into the oral argument and delighted when it made its way into the actual opinion of a distinction of the court kind of seized on thinking about this. Now that's the rarity. I would say sometimes you have more effect in the background, or it's important to get a position in. But to people who listen to your podcast, you're thinking, do I want to do an amicus brief or not? Would this be useful? I think the key question is there something about this case that the two major parties who are litigating it don't kind of see, or don't see it your way, or don't kind of have an incentive to kind of put before the court, where you think it's really important the court understands an issue. Because I can tell you, I love my colleagues who become judges outside of the federal circuit, which does most of the patent matter. Very few of them have any scientific background at all. And indeed, amusingly, in the case I mentioned, Mayo, Justice Scalia wrote this concurring opinion that basically says, I can't sign on to most of this opinion, including the factual allegations, because I don't understand anything about the science. And it's the only time he's ever written anything like that, or any justice has ever written anything like that. So there's a great moment of humility, but a reminder that the scientific community has a job to educate not only the regular population, but also the population of judges.
Yeah, I think it's the case with politicians as well, right? It's very rare to find a member of Congress or House that has a significant scientific background. They exist, right? But they probably all are thinking that on a number of the things that cross their desk, right? I want to ask about mitochondrial replacement as well. You've done a lot of work in this area, and it was the really last thing on the list I wanted to cover off before we close out. Can you talk, for people who aren't familiar with it, talk a little bit about the advances there and some of the legal, ethical challenges you're thinking about?
Absolutely, right? So mitochondrial replacement is something developed mostly in the UK in the Newcastle group, and essentially it meets the needs of mitochondrial disease carriers who would otherwise pass this on to their children. And these are terrible diseases who want to maintain a genetic connection. And what we essentially do, I think it's a bad term, 3-parent IVF, but it does capture the idea that we essentially combine the mitochondrial DNA of one woman with the rest of the DNA from another. And there are two major techniques. One is maternal spindle. The other is pronuclear transfer. And it is lawful to do in the UK under a special license. That was the process of a long 10, 15-year kind of process of consideration, including Parliament. In the US, though, we have an appropriations rider that was mostly focused on heritable genome editing, but has been interpreted to prevent mitochondrial replacement techniques and others from being considered by FDA. So it's not available here. And, so far, I would say the number of cases reported have been few and far between. There's a question about, in practice, how good it's going to actually meet the needs of this population. But I admire the way the UK had a very strong, reticulated, careful process for considering this. I joke that we had dueling op-eds in like the major papers, including one by the Archbishop of Canterbury. And I would love it if anything in our space would ever get this level of kind of sober attention, even if it turns out that we decide not to pursue it. I mean, look at other countries, Australia, Canada, even Singapore. I think all of them have better mechanisms for considering this stuff than we do. And this is what I mentioned earlier regarding the idea of this being a political hot potato, that it's rather unfortunate that we can't have sensible, sober lawmaking in the space as other countries do.
Yeah. Well, Glenn, I want to be respectful of your time. This has been a really fun conversation. Thank you. We hit a lot of stuff in a short period of time. If people want to keep track of you and your work, what's the best way to do that?
My center, the Petrie-Flom Center, has a great newsletter where we circulate stuff. I am on Twitter @CohenProf and on LinkedIn. If you Google me, you'll find me.
Amazing. Thank you. I appreciate it.
Thank you so much.
Thanks, everyone, as always, and we'll see you next time. Thanks, as always, for tuning into the Genetics Podcast. If you enjoyed today's conversation, the best way you can support the show is by sharing it with a friend or colleague who might find it interesting as well. We'd also really appreciate it if you could subscribe, rate, and review us on Apple Podcasts, Spotify, or wherever you listen to podcasts. This helps other people discover the show when they're searching for content on genetics, precision medicine, or biotech. We always want to hear from you as well. If you have feedback or questions or want to be featured on the show, you can email us at podcast@sonogenetics.com. You can find me on LinkedIn, Patrick Short. You can find us as well, Sonogenetics, on LinkedIn, or reach out on Instagram @The Genetics Podcast. And finally, a special thank you to the team behind the show who makes this possible. Joy Ismail produces and manages the show. Jane Reddy-Webster keeps us organized, and James Pierce from Selective Frequencies for his expert audio engineering. I'm Patrick Short, your host. Thanks again for listening, and we'll see you next time on the Genetics Podcast.